Hello, I'm Alex Gupta with UATV. Today I'm speaking with Professor Marike Paulsson. She is a professor of international arbitration at the University of Miami School of Law. Hello, Professor. Thank you for joining us.
Thank you for having me.
So we see Ukraine and Russia are meeting at the International Court of Justice in The Hague. Would you be able to tell us what this case is about and what has happened so far?
Well, actually, the issue with the case between Russia and Ukraine, not so many facts are known. As a matter of fact, the case that draws more attention in the Netherlands right now is not so much the case between Russia and Ukraine, but the Russia-Yukos case that is also taking place in the Netherlands, in The Hague. This was actually a case that also relates to an award rendered in The Hague under the administration of the Permanent Court of Arbitration, just like the case we're talking about now. It's just that the case between Russia and Ukraine is the International Court of Justice. The other one is the Permanent Court of Arbitration. And that one has made headlines worldwide and has really caused shock in the worldwide arbitration community and makes us reconsider whether or not arbitration works as a method of dispute resolution. So I think that what happened between the Russia-Yukos case is definitely something that's going to influence other cases that are going to be resolved through arbitration. It might have an impact on the case that is now in The Hague as well. So just to give you a little bit of background about the other case, this is a case we have more facts about that other case. This is a case where an award was rendered by a very prestigious tribunal. One of the members of that tribunal was Stephen Schwebel, who was the president of the International Court of Justice. And they assumed jurisdiction on the basis of an energy treaty. And somehow the court in the Netherlands, while having to address a setting aside request, has held that there is no jurisdiction on the basis of that treaty. The court has set aside that award, and this whole procedure is now still pending because there is an appeal. But at the same time, the enforcement requests have been filed in 3 different jurisdictions. So what happened here is that users of international arbitration, and obviously also states, wonder if we opt for arbitration, do the arbitrators have the last word, or do the courts have the last word? Now, the Russia-Ukraine case is a different situation, and we will have to wait what's going to happen in that case. And also, once the International Court of Justice has rendered a decision, obviously the mechanisms in place are completely different. At this point in time, The Hague and Russia are really making headlines because of the Yukos case.
Well, going back to the Ukraine and Russia case, I know Ukraine is seeking provisional measures. Would you be able to explain what provisional measures are and what the standard of provisional measures is?
So provisional measures, that is something, you have the UN Charter, and then you have the rules for the International Court of Justice. Now, I also have to say up front, my expertise is really international commercial arbitration and not so much the International Court of Justice rules. So provisional measures, those are measures requested before the International Court of Justice under that statute of the International Court of Justice. And I have not yet looked specifically into the Ukraine case, so I cannot really tell you at this point how high the chances of success are for those provisional measures.
Okay. So is there a certain burden of proof, though, that Ukraine needs to meet in order to get?
Yes.
There is? Would you happen to know what those are?
No, not off the top of my head. The problem with the International Court of Justice is you have, I don't know how familiar you are with the International Court of Justice, but it works differently from the other tribunals and arbitrations that are administered in The Hague. And it's going to depend very much which judges are going to be working on this case. And it is also very much it's more political than, for example, a case that's going to be administered by the Permanent Court of Arbitration. So at this point, I think it's really hard to say how difficult or how feasible it's going to be to get those provisional measures.
Okay, so that's interesting. The International Court of Justice is more political. Going back to Russia versus Georgia, was that more politically motivated, or was that more nonpartisan?
I could not tell you because I have not looked into that case. My focus has very much been when I actually used to represent Russia when I was still practicing in Europe. And the cases that we did were more the cases focused on the cases against Yukos and also the cross-border insolvency cases. And I have to say that with those cases, it is really less political. We're really applying the arbitration rules. The burden of proof, the rules are free, which means that the arbitral tribunal can decide what kind of evidence needs to be submitted. And once that case is then finalized by the tribunal, it goes to court, and there the rules are the same, which is to say that the rules are, it's discretionary for the judges or the arbitrators to decide, okay, this party needs to submit more, or we're going to reverse the burden of proof. So there's really, what is important to know, you need to make a distinction between the ICJ cases on the one hand, where Russia is involved, and then Russia is involved with either commercial arbitration cases or the litigation cases. And somehow, most of these cases where Russia is involved, they're brought to The Hague. Whether it's the International Court of Justice, the Permanent Court of Arbitration, or actually the Dutch courts, interestingly enough.
I know Russia is saying that the International Court of Justice has no jurisdiction over this case because one of the requirements they're saying is that Ukraine and Russia have to meet for arbitration. They at least have to agree on a certain set of rules for arbitration. Is that correct?
Right, and so this is Article 36 of the International Court of Justice rules, and this is very complicated. Actually, as a professor, I always try to emphasize this with my students. So this is, I would not call it a weak spot of the ICJ, but the problem is here when one wants to hold a state accountable. Article 36 of the ICJ rules provides that there needs to be consent for jurisdiction. And needless to say, this consent is really hard to obtain once a dispute is ongoing. And that's one of the difficulties, how to meet the requirements of Article 36 and how to get that consent. We see this problem with Article 36 also in many other cases. So, for example, when states need to be held accountable on the basis of state responsibility, so when they have breached a treaty, for example, so some states actually breached the New York Convention, you want to hold them accountable. How do you hold states accountable? You go to the International Court of Justice. If there is not, for example, the New York Convention, a dispute resolution provision where states agree up front to go to the International Court of Justice, you need to get this consent on the basis of Article 36. But once there's a dispute, it's hard to get that consent. And we do a lot of research at the University of Miami with the International Arbitration Institute, and we try to find ways with our students to hold states accountable. And the one thing we're constantly confronted with is Article 36, that consent requirement.
I see. So
that's
all right. I know that this case, the ICJ, their decision is binding. What does that mean when they say the decision is binding on all the parties?
So, okay, let me try to give you the answer the way I try to explain it to my students. The decision is binding. However, this is in the realm of dispute resolution, like arbitration, where you don't get a court decision. So the question is, even though the ICJ rules and the International Court of Justice will say and will hold this decision is binding upon the parties, that means in the context of international law and the international order that states need to comply with that decision. It's binding on the states. This is the theory. However, the question is, how do you actually ensure that states respect the fact that the decision is binding? So what kind of sanction mechanisms do you have? And this is really where we see that international law is different from, for example, national laws, because when you have a court decision between private parties in a country, you can enforce that decision. You can execute that decision. In the international realm, the international order, enforcing decisions in this context is going to be a lot harder. For example, in the New York Convention, you can get enforcement judgments. With this, you can't. So the decision is binding, but you still really have to rely on the goodwill of states to actually respect those decisions. If not, you need to think of sanction mechanisms, but then we get into an area of international law that we actually don't want to get into. And this is, again, one of the weak spots of international law. How do we hold states accountable, and how do we make sure that states comply with these decisions? So, for example, I don't know whether you're aware of the China case, the China-Philippines case. Here, a decision was rendered by a tribunal. The decision is binding on the two states. And one of the countries has said, well, we're simply not going to comply with it. We are not recognizing the authority of this tribunal. So that's something, when we're trying to hold states accountable, it's a challenge.
Well, thank you so much, Professor Paulsson, for joining us. Really appreciate it.
Thank you.
I'm Alex Gupta with UATV. We are speaking with Professor Marike Paulsson. She is a professor of international arbitration at the University of Miami School of Law. Thank you so much.